constant petition, I am bringing in question the order dated 31/10/2025, my lords, wherein our petition was solely dismissed on the ground of availability of alternate remedy under section 66(2) of Drugs Act, my lords. What my humble submission is, my lords, for easement, my lords, I have uploaded the written arguments on ERP, my lords. That may kindly be seen, my lords.
How many children died due to this syrup?
My lords?
How many children died due to this syrup?
My lords, we were merely the distributors of that drug, my lords.
Later on. पहले तो आप इसका जवाब दें कि how many children died?
More than 30 children, my lords.
27. And thereafter, the show cause notice was issued and action taken against you.
My lords.
You are challenging it.
My lords, we were challenging.
You are invoking the writ jurisdiction.
My lords, we are invoking.
Action under the provisions of the Drugs and Cosmetics Act.
I was invoking the writ jurisdiction on the behest of violation of natural justice, my lords. And Honorable Apex Court is very clear that
this is a case where they are taking very. They are not taking actually proper action against you.
Still being lax.
My lords, if I may kindly make a small submission, I am merely a distributor.
Who supplied this syrup to the hospital, Chindwara Hospital?
My lords, I am merely a distributor. I am merely a bona fide distributor, my lords. On 2nd of October, my shop was seized without any proper following the process, my lords. And all the documents and necessary things which were required for my defense were logged in my shop, my lords. On 2nd, they sealed my shop. On 5th, they collected certain samples. And on 8th, they collected certain samples. And without having any report of the medicine which they seized from me, on 11th, they issued a...
Alternate remedy of appeal is available.
My lords, I humbly bow down to the...
The writ court think that the writ court should exercise the writ jurisdiction.
Lords, I humbly bow down to the alternate remedy point, my lords, but what my humble submission is, we are ready to participate in the whole process. This order dated 11/10 shall be remanded back. We shall be awarded an adequate opportunity of being heard. I am just praying for that, my lords. I am not demanding any quashment of proceeding. I am just saying that the proceeding shall be taken out in a fair and justified manner. They have just issued the show cause notice to me on 9th and 11th, and on 11th only they have passed the order of cancellation of license without having any basis, without having any report of the drug which they sealed from me. And on 2nd, anyhow certain officials came to my shop and sealed my shop. That too, if we go through the provisions of Drugs Act, section 22 and 23 does not empower the drug inspector to seal the shop. And on contravention of provisions of Drug Act, they sealed my shop, my lords. They have fully made a joke out of the provisions of Drug Act and carried out such proceeding against me. Those are totally, my lords, what my humble submission is, violating the natural justice, my lords. I am merely there on the ground of violation of natural justice. My whole argument revolves around the point.
What about justice to the children who died?
My lords, that is a matter.
Justice for them.
My lords, I sincerely bow down to that founding. That is a matter of investigation, and we are ready to participate.
226 is not a statute. Is not a mandatory remedy. It's a discretion of the court. Court has decided not to exercise it. You have remedy available in law. Exercise that.
My lords, I sincerely bow down to that. But what
Even
my humble submission
even if it is wrongful closure of your shop, file an appeal. Appellate authority will consider.
We'll file that appeal. But what my humble submission is, I am nowhere disputing that I will not participate in the proceeding. I am just disputing the fact of bias proceeding being carried out against me.
Appellate authority has the power.
Let's appellate authority is having the power, but under 226, Honorable High Court is also having the power as per the Apex Court guidelines, my lords.
226 is extraordinary discretionary remedy.
My lords, that I
Court
go
has
down.
refused to exercise discretion. We are not going to interfere with it.
I am humbly trying to back something out of that discretion. My argument revolves around the discretion only, my lords, because of which I have made these arguments. I may kindly be allowed to make threefold submissions. Why I am justifying this order being wrong, my lords. If I may be granted a couple of minutes.
Nothing wrong with the order. Court has said go before the appellate authority.
Lords, I am not saying anything that, as my lord says, that is completely discretionary. So I am trying to move certain thing out of the discretion of this honorable court, my lords. My argument is just to pursue something from discretion of this honorable court so that I can get some relief, my lords. My lords, as Apex Court is clearly clear on the issue, as I have summarized in my arguments, my lords, that exception to rule of alternate remedy arises where the writ petition has been filed for enforcement of fundamental right, firstly. Secondly, where there is violation of natural justice. Thirdly, where the order of proceedings are wholly without jurisdiction. And fourthly, the wires of legislation is challenged, my lords. All the argument rests on point B, C and D, my lords. That too I'll establish how, my lords. If we'll go on reading on the order of 11/10/2025, it could clearly be seen that on 2/10/2025, my shop was sealed by the drug inspector, which is not authorized to do so under the provision of Drugs Act. And Honorable Apex Court is also very clear on the aspect that if any drug inspector exceeds his capacity in sealing the shop, that sealing is illegal and the shop needs to be open. The relevant citation also I filed in the ERP, my lords, and I am also having a hard copy if my lord requires it, wherein the Honorable Apex Court was also clear that drug inspector is not at all authorized to seal the shop. Now here how I fall under the exception to alternate remedy, I'll demonstrate. In the clause 3, part B, it clearly says that the proceedings are wholly without jurisdiction. Under this exception, the act of drug inspector is wholly without jurisdiction. He was not having the jurisdictional capacity to seal my shop. How he sealed my shop? This is the first full argument, my lords. The second one is,
When was your shop sealed?
on 2nd October, my lord, 2nd October 2025, it's clearly mentioned in the 1110 order, and also we were not provided with any document, pre-intimation or order as to why our shop is sealed. Suddenly certain officials came and sealed our shop merely on pretext of these news circulars been going on that the drug, because of which such tragic incident occurred, we were the distributors of it. Merely on basis of this our shop was sealed, and certain drugs were sealed for the certain drug samples were taken for investigation.
You are challenging suspension of your license, or you are challenging closure of your shop?
I am challenging the process starting from 2nd October to 11th October, wherein my shop was sealed wrongly, and on the 11th October, where my license was cancelled without awarding me an adequate opportunity of being heard. That too I'll demonstrate, my lords.
On 9th October?
9th October I was...
show cause notice given, 11th October show cause notice given.
And on 11th October only the order of cancellation of license was also passed,
right,
wherein I provided them a letter on 10th October that in order to furnish the reply, I need some time, I need some documents. The documents are logged in my shop shutters may kindly be rolled up so that I can grab the documents and file my adequate reply.
Please file an appeal.
My lord,
File an appeal.
my lord, certain relief, I humbly pray that certain relief may kindly be granted to me. It may clearly be seen from the order that there is a clear violation of natural justice, my lords.
Mr. Billa, we are giving you the relief of going file appeal.
My lords, that is an available remedy to me. I am not disputing the fact, but I am just making a small submission that I am ready to participate in the whole proceedings, but the proceeding may kindly be reverted back. The 1110 order of cancellation of license was also not communicated to me. On the news article of 1310, I came to know that my shop license has been cancelled. Then when I inquired about the reason why my shop license was cancelled, I was supplied the order also on or after 15th of October. What my humble submission is, the order is passed on back of me. And there's a clear thing, my lords, that all ultram partem, the other party needs to be heard before passing an order with, which anyway infringes his right, my lords. And also under section 19(3), all the defenses are available to me, which I ought to have shown to the authorities during the time when my license was cancelled, but I was awarded no opportunity of hearing. So what my humble submission is, the proceedings may kindly be remanded back. I am ready to participate in the proceeding, my lords, because this is an ultra-wise proceeding, my lords. It will take a huge amount of time to go through the appeal and go through the process. My shop is closed, n number of financial losses I am facing, and also apart from this company drugs, other drugs are also stored in my godown, my lords. Because of this illegal sealing, those drugs are also perishable in nature.
At the time of inspection, whether the syrup was found in your shop or not?
My lords, it was found because I was one of the distributors. I am not disputing the fact that syrup was not found. But my humble submission is...
It was stored in your shop, therefore the action was taken.
My lords,
You can't say that the action has
The
been
syrup
taken
was
without any
stored in
basis.
my shop merely under the capacity of distributor of that company. I am not the manufacturer of the drug, my lords.
Naib Tehsildar has sealed your shop, not
Yes.
the general
My lords,
store.
the drug inspector has
Therefore.
sealed my shop, my lords,
That is
along
written.
with presence of Nayab Tehsildar, but the drug inspector was the person who sealed my shop, my lords.
It is written in the order.
Under the orders of the Naib Tehsildar.
But my lords, but without providing me any opportunity, can they seal my shop, my lords? That is
You
the
are selling
concern,
a
my
drug
lords.
Which is causing harm to the children.
Fatal.
Why action should not be taken against you? And you
My
should
lords,
wait.
only the
Why
stock
they will
of
wait
cold drift
after
ought to have
issuance of
been.
Chokas notice, you will called up, then you will file a reply, then the
My lords,
appointment of
these are the
meeting.
what my humble
exceptions.
submission is, I am not the exclusive distributor of cold drift, my lords. Other drugs need not be sealed, my lords. My shop need not be sealed in relation to the other drugs. I am merely a bona fide distributor, my lords. I am not the manufacturer, my lords, whose neck is directly to be grabbed by the authorities, my lords.
You are the stockist who supplied the salary
That's, I
to
am
the hospital.
humbly making a submission that I agree that I am a distributor, but the thing is, I am a bona fide distributor. I am not the manufacturer of the drug, my lords. That is my humble submission. That I am ready to participate in the proceedings with my whole heart, and I'll cooperate. But the proceeding needs to be carried in a justifiable, lawful manner, my lords. It need not be carried out that once a show cause notice is issued to me and on the next date, without awarding an opportunity of hearing, they are passing the orders of cancellation of my license. Already because of this media trial, I am also facing certain disturbances on my brand name, my lords.
File your appeal, you are having a remedy to challenge.
I am
the order.
humbly agreeing that I am having alternate remedy, but under 226 I can approach this honorable court if there is violation of natural justice. My whole argument relies solely on the aspect of violation of natural justice, my lords. That's why I am humbly pursuing this honorable court to move somewhat its discretion in my favor also, my lords, so that I can grab some mercy of this honorable court, my lords.
No equity in your favor.
My lord,
No equity in your favor.
my lords, it may clearly be seen from the whole incidents which we can see that I am merely a bona fide distributor. I am not the manufacturer of that drug, and also I am dealing in other drugs.
Section 18C of the Drug Act
Section 18C.
empower them to take action against the distributor, stockist, and any person who sells.
I agree, but to it also there is a defense available under section 19(3), which I ought to have taken the defense of if I would have awarded an opportunity of hearing. My whole argument merely pressurizes on the aspect of opportunity of being heard needs to be granted to the petitioner against whom such order is passed. I was not awarded an adequate opportunity. They have issued a reminder show cause notice to me on 11th, and on 11th only they have passed the order of cancellation of license. Then how we can justify the adequate opportunity of being heard?
First notice was issued on 8th, it was served upon you.
It was served upon me on 9th at 11:30 in the night.
Second notice was issued on 11th, and thereafter they have taken
Malas,
passed the
to
order.
it also we have filed a reply that
Passing
in
the
order.
time. You were
Malas,
simply passing the time.
I was not at all passing the time. I humbly made a request that I need to furnish my reply, and I just made a mention that thing has also been taken there on the order sheet, that I may kindly be allowed to enter in my shop and take out the documents which are necessary for me to furnish my defense. Just in order to furnish my defense, I need certain documents, and those documents are there in my shop, and my shop has been illegally sealed on 2nd of October without any prior intimation or without awarding any opportunity of hearing at the time of sealing of my shop. The violation of natural justice starts from the day they sealed my shop on 2nd of October till 11th of October, where they passed such order without awarding me an opportunity of hearing and without allowing me to equip me with the documents which I need for my defense.
Mr. Consil, you are just repeating your argument again and again, again and again. Nothing.
Well, I am just
nothing else.
repeating in the hope that I can move some.
You have repeated this argument 10 to 15 times.
I am moving in the aspect that I can grab some benefit from discretion of this honorable court. That is the sole purpose of me
Discretion not
repeating the
granted.
same thing, my lords. Lords, I humbly pray that certain relief may kindly be granted to me by looking on the order of 1110. It could clearly be seen what I am pointing out repeatedly, my lords. The bare perusal of the order could clearly make out on face of record that I would not awarded an adequate opportunity of hearing, my lords.
When did the first child die?
My lords, that record is not there in the petition.
August.
In month of
Then
August.
September, and you continue to supply these
No,
drugs?
no. There's no available document on record which could show cause, which could establish that I continue to supply the drug, my lords. And the reason why that child died and whether the drug sample because of that child died was whether supplied out of my outlet or not was also a matter of investigation, and without having any investigation
You
they
admit-
have
you
issued a
admitted-
permanent suspension or a
You have
permanent
admitted that-
termination of my license.
You have
So-
admitted 660 bottles purchased, out of which 594 distributed, only 66 bottles left with you.
My lords. I am
And the
being
death
one of the
started happening from
distributors.
August onwards.
My lords, I am being one of the exclusive distributors. Then, my lords, such small quantity could have been circulated. That is a very small quantity for a distributor, my lords, to distribute 594 bottles.
How many
It's
children
not a
died?
huge quantity.
How many children died?
My lords, around 30 children. I
30
go down to
children
that
died.
finding, my lords.
With this small quantity, 30 children died. If it was a large quantity, how many would have died?
But that is a matter of investigation against
Let that
against the
investigation carry
manufacturer
on.
of drug. I am merely a distributor, that too a bona fide
Mr. Villa,
distributor.
We have no sympathy, no empathy for a person like this. Learned single judge has refused to exercise discretion, so do we.
My lords, see,
You wish to
merely-
file an appeal? Don't repeat your arguments. We've heard it 10 times. We are not inclined. We are not inclined to exercise discretion in a case like this. You want us to pass a speaking order? We'll pass it.
My lords,
You want a speaking order?
my lords.
Take down. Appellant impugns order dated 31/10/2025, whereby the writ petition filed by the appellant impugning the sealing of the shop of the appellant as well as suspension and cancellation of his drug license has been dismissed. Learned single judge by the impugned order has noticed that appellant has an alternative efficacious remedy of an appeal in terms of Rule 66 within bracket 2 of the Drug Rules 1945, whereby an appeal is permitted to the state government. Para. The subject case is one of the most shocking cases in the medical history, where as many as 30 children have died by alleged consumption of a cough syrup by the name of cold reef. The death started happening in the month of August, September and October. The appellant admittedly is a distributor of the cough syrup cold reef. A raid was conducted on the premises of the appellant on 2nd October. 2nd October?
My lords, on 2nd October, it was the first day.
2025, where stock of the said medicine was found. Shop of the appellant was sealed, and thereafter on 8th October 2025, a show cause notice was issued to the appellant to show cause as to why action under the drug and cosmetic rules be not taken of suspension and cancellation of the license.
It's 9th.
My lords, it's 9th.
9th
And the
of
show cause notice was first issued to me and
Show cause
served on
notice
me
dated
at
show cause notice, sorry, dated 9th.
my lords.
The
Inspection was on 8th.
Thereafter, another show cause notice was issued on 11/10/2025, giving appellant time to respond on that very day.
My lords, we
However-
filed a reply also, that may kindly also be noted. On 10th of October, we filed a reply that we
Asking
need
for
to
time.
asking for time and asking for access to the documents which we need to furnish our
It is
defense.
the case of the appellant that appellant had filed a reply on 10/10/2025, asking for further time to respond on the ground that the documents of the appellant were lying sealed in the subject premises. Para. Learned single judge has noticed the provisions of Rule 66 of the Drug and Cosmetic Rules
1945.
1945, which provides for an appeal and has declined to exercise the jurisdiction under Article 226 in favor of the appellant. we are of the view that appellant has an efficacious alternative remedy of filing an appeal before the state government. Full stop. The remedy under Article 226 of the Constitution of India is not an absolute remedy, but it's a discretionary remedy. In the facts of the given case, learned single judge has refused to exercise discretion under Article 226 of the Constitution of India. We are in agreement with the view taken by the learned single judge that this is not a case where the court should exercise discretion under Article 226 of the Constitution of India. Full stop. In case an appeal is filed by the appellant, the state government, before the state government, the state government would be entitled to look into all the facts and circumstances of the case to decide the said appeal. We find no infirmity in the view taken by the learned single judge. The appeal is according, and any merit in the appeal is accordingly dismissed.
Hon'ble.